Hello, my name is Dr. Tamàs Fézer. I'm an assistant professor at the University of Debrecen in Hungary. I'm teaching civil and commercial law, both in a European and a Hungarian perspective, mainly torts, contracts, competition law, and corporate law. I spent 5 months as a Fulbright scholar here at Indiana University, and IU Kelley School of Business asked me to give some lectures on various European law topics, private law topics. Today's lecture is about the legal profession in Europe. First, we will have a look at the whole civil law legal system, some basic doctrines and conceptions of the civil law legal systems where the European lawyers work. Then we will examine the role of judges, prosecutors, advocates, and finally notaries to identify the most important differences between the US and the EU. And finally, we will take a closer look at the migration rules in the European Union for lawyers. Before we start to analyze the exact professions, judges, prosecutors, attorneys, we have to take a short look at the basics of a civil law legal system. As far as most of the European Union member states are following the civil law legal traditions, this legal system gives a general background to legal professions. One of the most important doctrines of the civil law legal system is the supremacy of statutory law. The doctrine stresses that all rules of law have to be stated in statutory instruments, acts, regulations, and ordinances. Common law and judicial precedents do not exist. Judiciary cannot override or neglect the statutory provisions. The law can be modified only by the legislator. Another significant doctrine, the due process of law, makes the supremacy conception whole. The due process of law ensures that statutes have to be promulgated before application. Usually, a national official journal exists in every country where these new statutory instruments are published. The due process of law is about predictability, certainty for the citizens. Every individual has a right to know his rights and obligations stated in the statutes before being judged under these provisions. Predictability and certainty prohibits the so-called contra legem judicature, namely judicial decisions against the statutes. The court system is also different in Europe. The Supreme Court is a court of appeal, but still a court without the power of formulating or overwriting statutory rules. To control the work of legislation, a special body exists, the Constitutional Court. The Constitutional Court does not belong to the ordinary court system, and the court doesn't deal with real cases. They decide whether a certain rule in the statute is in conformity to the Constitution or not. If the Constitutional Court finds that a provision is a violation of a constitutional rule, he simply annuls the problematic provision, and this provision will no longer be applicable. Even a single citizen can address a question to the Constitutional Court, so the court is open to the public without a real existing legal debate. Another important factor is the speciality of the civil procedure in Europe. A legal process in a civil law legal system is a continuous series of meetings, trials, hearings to discover evidences. The civil law judge has an extensive power that often tempers the party control and supervises and shapes the fact-finding process. No depositions exist, everything happens to the order of the judge and in front of the judge. The judge sends subpoena to the witness, he has a right to address a question first to the witness. In civil law cases, there is no jury in the civil law legal systems. Only professional judges rule. This will be an important element to understand the work of an attorney, as there is no use of dramatic trials because of the lack of laypersons. While there are some cases where laypersons are involved in the procedure, but not because of their impartiality, more for their experiences. A good example is an intellectual property case, an IP law case, where usually a judicial council has to deliver a decision, and the council consists of a professional judge as a chairman and 2 laypersons, engineers or other experts of that particular case, such as a patent case. And now, let's start our examination with the judges. Judges in Europe are more like public servants than lawmakers. Because of the supremacy and due process of law doctrines, the main role of the judge is to apply the statutory rules to that particular case. He has no right to modify these rules. A certain interpretation is necessary, even if most of the abstract legal terms have an exact definition in the acts and regulations. This interpretation can lead to different operation in law in different parts of the country. That is why an internal and external hierarchy exists in the court system. Lower courts have to follow the harmonized decisions of the Supreme Court. The Supreme Court delivers a harmonized decision when there is a diverse interpretation of a certain provision. The internal hierarchy means that beside the president-vice president structure of the courts, special divisions can be found on courts, such as civil law division, criminal law division, labor division, administrative division, and economic division. Judges belong to one of these divisions, and they have regular meetings to discuss interpretational problems. The career of judges in Europe is a classic course of life. Career job judges start to work on court as court trainees right after graduation. After a certain period of practice time, it can be between 2 or 4 years, depends on the member state, they have to pass a legal specialist examination and they can get a court commissioner position. A commissioner has limited jurisdiction in smaller cases, such as registering a company. After being a commissioner for a certain period of time, usually this is shorter than the period for trainees, they can apply for the job to be judges. Judges are appointed by professional judicial bodies and not elected by the people. Professional skills, abilities count, and they have to pass exams on a professional and psychological level. Once they are appointed, some states require a probationary period, usually 3 or 4 years. During this period, their work is monitored, and at the end of this probationary term, they can get lifetime assignment. Prosecutors. Prosecutors have the same importance in criminal cases as everywhere in the US. But a European prosecutor is considered to be a guardian of legality. That is why prosecutors play an important role in civil cases as well. They can be plaintiffs in cases where an unprotected party's interest needs to be defended, such as minors or people whose whereabouts are unknown. Prosecutors can also enforce law in private relations. For example, they can represent public interest to determine an annulled marriage. And prosecutors have a general competence on legal entities. They supervise companies to observe the law. For us, the most important profession is the profession of lawyers, attorneys. In general, legal education in Europe focuses mainly on theoretical questions. Because of the lack of juries and laypersons, trial techniques are less important than a general, almost scientific knowledge of law and the system and coherence of rules. Bar associations usually play an important role for lawyers. Bar associations are not only professional organizations that give certain services for their members, but authorities who supervise the work of lawyers. That is why membership in bar associations is mandatory for a European lawyer. Bar associations decide on giving a license to practice, cancel the license in case of a major ethical or legal violation, and they often establish fee schedules and other ethical rules. An interesting significance of these ethical rules is that advertising is generally prohibited and considered to be unethical for lawyers. Lawyers have 2 types in a civil law legal system in Europe. Advocates are close to the well-known US attorney model, and notaries have a special role in solving legal problems. First, let's take a closer look at the work of advocates. Excluding the UK, internal hierarchy of advocates is not common in Europe. An advocate has a right to represent a client, draft legal documents. There are not different levels of advocates, only in the UK. We talked about the mandatory Bar Association membership for European advocates. Bar associations also play an important role in supervising the lifelong learning concept. The EU encourages member states to introduce special rules on professional training for lawyers. As in our world, new challenges arise for lawyers almost every day. Just think about the conquest of electronic procedures, e-documents. Bar associations often state special requirements for their members to take part in these trainings. Trainings usually work in a credit system, and advocates have to earn a certain number of credits in a period of time. Although being an advocate is a market job, there are certain restrictions and strict ethical rules adopted by the legislator and bar associations. In Europe, we have countries where contingent fee is considered to be unethical, and bar association fee schedules limit the margin in negotiating advocate fees. Big law firms are not common, especially in Eastern Europe, and generally in the European Union, individual advocates or small law offices with probably 2 or 3 partners are typical. The work of advocates is still in close connection with legal procedures, court representation, or drafting legal documents where the law requires the counter-signature of an advocate. Hiring a lawyer to manage a settlement agreement is less common than in the US. Self-representation on court is still popular, especially in civil law cases. That is why finding clients and running a successful practice can be really difficult for a European advocate. Beside these restrictions and bar association regulations, an advocate is free to do everything that is not illegal to protect the interest of the client. Client-advocate privilege is above all. Letters, emails, conversations, even meetings between the client and the advocate before hiring the advocate are strictly confidential. Advocates can use every legal instrument to protect the interest of their clients. They cannot be witnesses in the particular case, even if their assignment ended. Advocates also have an important role in supervising certain documents. Many member states of the European Union adopted rules on transactions that require the work and signature of an advocate. A classic example is a real estate transaction that is only valid if an advocate forms and signs it. Another example is establishing a company. Those member states following the German normative condition system on registering a company require that all necessary documents, including articles of partnership, have to be prepared by an advocate. This function of an advocate ensures a preliminary control on these transactions and documents before entering the legal procedure. And now let's say some words about the liability. Liability of the advocates is on a special level. They have to take every legal effort to protect the client's interest and have to use their best knowledge to manage the case. In Europe, every advocate needs liability insurance. This is one of the preconditions when admitting to the bar associations. Now we have to examine the possibilities of migration for lawyers in the European Union. One of the 4 freedoms in the European Union is the free movement of persons. The free movement of persons is in close connection with the right of establishment. Many interpretations of the European Court of Justice and modification of the Roman Treaty made it clear that right to establishment and provide services in another EU member state are fundamental rights for all kinds of businesses. And lawyers belong to this category as well. To concretize these freedoms stated in the Roman Treaty, EU institutions have a right to adopt secondary law, usually regulations and sometimes directives. Before we take a closer look at these regulations, a deeper analysis of these free movement rights is needed. Discrimination based on citizenship is prohibited inside the EU. Member states have to permit foreigners from other EU member states to run their businesses in another country without adopting further requirements and burdens for them. The only exception under this rule is professions that belong to the executive power. These professions, traditionally judges, police officers, other public servants, can still remain professions reserved for the citizens of the particular member state. In the so-called Reiners case, the European Court of Justice ruled that lawyers, advocates, do not belong to the executive power. Legal profession is simply one of the classic business activities, and there is no lawful reason on restricting it. Freedom of practice in another member state for lawyers started with the Service Directive in 1977. The directive is applicable in cases when a lawyer from a member state would like to provide services in another member state on a temporary basis. This directive is in close connection with the freedom to provide services and focuses only on temporary activities. Representing a client in another member state, providing services for clients in another member state were the first steps in EU legislation to open the market for lawyers. Well, of course, the Service Directive doesn't deal with permanent establishment, opening and running a law office permanently in another member state. It emphasizes only the service part of the job. An important step to full integration of lawyers practicing in another member state was the Directive on Mutual Recognition of Diplomas. The directive's general rule is that every profession requiring at least a 3-year-long professional training to get the diploma is automatically recognized in another member state. No matter where the lawyer earned his diploma, where he had the professional training, his qualification is valid in every member state. One of the acceptable reasons of a member state to create further requirements for foreign professions is if he verifies that a significant difference exists in the training of the home country and the host country. To terminate the gap, the host country can prescribe a special adaptation period or an aptitude test. Again, this doesn't mean that the foreign specialist has to earn another diploma in the host country. This is only a complementary training to prepare him for the host country's specialities. Another exemption under the main rule of recognition is if the professional training period is significantly shorter for the particular profession in the home country than in the host country. The host country can live with the possibility to prescribe an adaptation period in order to make the training whole. But excluding these two reasons, the mutual recognition of diplomas is general for all professions in the European Union. After having a brief overview on the general background directives on running a business, providing services in another member state, we can focus on lawyers. According to the valid EU law, there are two ways of practicing in another country. The first and less problematic solution is when the lawyer uses his home country professional title in the host country. Under the home country professional title, they can establish an office and become a member of the host country bar association. The only obligation for a foreign lawyer is to register himself in the host country's list of lawyers. The registration is automatic, it's only a formal act. If the lawyer provides only temporary services in the territory of the host country, there is no need to register. The lawyer has to use his home country professional title in his language, and this title has to be translated to the host country's language as well. An important rule to protect consumers is that this translation cannot be the same or similar to the host country title. This provision helps consumers identify that this particular lawyer was graduated in another member state. The lawyer using his home country professional title can provide legal counsel on his home country law, EU and international law, and even the host country law. As you can see, his potential activities are hardly different than the activities of a native lawyer in the host country. Beside the distinctive title, other restrictions can be applied by the host country as well. EU law enables member states to establish restrictions and exclude certain activities of a lawyer using his home country professional title. These restrictions are in close connection with high-level representation and activities that have a connection with not only protecting a client's interest, but ensuring professional control on special documents. A possible restriction is that a member state can prohibit the making of a lost will or real estate transaction for a lawyer using his home country professional title. It can remain an exclusive right for lawyers using the host country's professional title. The host country can also reserve the right of representation on court for lawyers graduated in the country. Another version of this restriction is when representation is available for the foreign lawyer, but only together with a native colleague. And finally, one of the most classic restrictions in representation in front of the Supreme Court for only lawyers with the host country professional title. Mainly because of these possible restrictions and the clear difference of titles, practicing under the home country professional title is popular among lawyers who are working as employees or consultants at a law firm in another member state. Running an individual practice under the home country professional title is not common in Europe. The other form of practicing in another member state is the full integration. The Establishment Directive marks the conditions on how to be eligible for using the host country professional title. Full integration means that no difference exists between a lawyer graduated in the member state or a lawyer graduated in another member state. To earn this right of using the host country professional title, foreign lawyer has to prove at least a 3-year-long practice in the host country. During this 3-year-long practice period, the foreign lawyer has to deal with the law of the host country and/or EU law. As we saw, using the home country professional title enables the foreign lawyer to give legal counsel on the host country law. If the foreign lawyer can prove this activity in the host country, he is eligible to get the right of using the host country professional title. That's the full integration. Another way of getting the host country professional title is when the professional practice in the host country is less than 3 years, but the foreign lawyer can prove that special seminars, trainings completed his knowledge in the law of the host country. This exceptional situation is based on the discretion of the host country authorities, so it's not a general rule. Once the foreign lawyer gets the host country professional title, there is no difference between lawyers earned a degree in the country or earned a degree in another member state. A relatively new perspective of practicing in another member state is the right of mobility for not yet fully qualified lawyers. The European Court of Justice, the ECJ, analyzed this special situation in his decision, the famous Morgenbesser case. The case was about a French national who studied law in France and subsequently worked as a trainee lawyer in Italy, but was refused admission to the bar as a lawyer in Italy. ECJ held that bars and law societies are obliged to take into account of relevant experience and qualifications gained in other member states of the EU for the purpose of admitting lawyers, with the proviso that they can require them to undertake further study or practical experiences if necessary to bring them up to the same level as a fully qualified lawyer. The Morgenbesser decision concluded that the EC Directive on mutual recognition of diplomas is about professions and not traineeships after graduation. The right to mobility is available for those lawyers who have a law degree but haven't fulfilled their traineeship period. We talked about the fact that after graduation a professional practice is required before admitting the bar. If this professional practice is missing or not complete, the competent authorities of the member state must take into account all qualifications of EU nationals seeking entry into their profession. And after passing additional trainings, seminars that are necessary to be fully qualified lawyers, admission to the bar cannot be refused. This illustration on the slide shows the possible ways of practicing as a lawyer in another member state. Practice on a temporary basis is based on the rules of the Service Directive, and no further requirements such as registration, adaptation period, or trainings are needed. To gain access to the host country legal profession on a permanent basis, the Establishment and Diploma Directives offer two possibilities. Using the home country professional title, that certainly means restrictions, or using the host country professional title and being fully integrated in the host country legal profession after a 3-year-long practice. And finally, the Morgan-Besser formula opens the market for not yet fully qualified lawyers who wish to get their practice experience in a member state other where they originally graduated. In this latter case, additional training requirements can be applied. Legal profession is a special profession, as national legal systems in the European Union are still different and have their own historical, social, economic traditions. Earning a diploma in a member state doesn't mean that the lawyer is familiar with the law of other member states. Because of the significant differences, these restrictions are necessary, as we are not talking about professions using a universal knowledge, such as medical doctors or engineers. And if we take a short look at this chart, we can see that full integration is not common in the EU. From the approximately 750,000 registered lawyers in Europe, only 169 chose to practice in another member state using the host country professional title. Using the home country professional title is more popular, as, especially being a counsel or employee at a foreign law firm, it doesn't have special requirements. It's hard to tell how many of these lawyers are giving counsels on the host country law or just dealing with home country EU or international law cases. Probably most of them deal with the home country or EU and international law. If you would like to find a lawyer in Europe, the best way is to browse the website of the Bar Association local chapters. As membership in the Bar Association is mandatory, you can find an up-to-date list on lawyers every time. Eurojuris International also has an extensive website on lawyers registered themselves at Eurojuris. And if you need a lawyer who is familiar with EU and international law, Lex4's website can help you find him. As I mentioned before, lawyers have two types in Europe. Beside advocates, a special society of lawyers exists, the notaries. The notary is a person with law degree and bar exam, but his activities are not about representation, more about authenticating and providing authenticating services to the people. The notary is appointed by the bar and assigned by a state body, usually the Minister of Justice. Notaries are half private entrepreneurs and half public servants. After they get their assignment, they can run their offices, but the number of notaries is limited. It depends on the number of inhabitants in the particular district. Notaries are considered to be a prolonged hand of state, and to understand this we have to take a closer look at the functions. Functions of the notary can be divided into 4 categories. Drafting legal documents is a general right for notaries, although not an exclusive right. The advantage of having a contract countersigned by the notary is the easy enforcement. A general presumption is that having a notary-signed document is a public document, difficult to prove that facts stated in it were not valid or true, or didn't happen. Notary implements special security steps to prevent documents from forgery and subsequent modification. If parties of a contract would like to establish a contract that is a strict evidence of their legal relationship, this is the best way. If one of the parties fails in fulfilling his obligation, legal enforcement doesn't need preliminary court trial. The party can claim enforcement automatically because of the presumption of public and valid document. An important part of the notary's activities is authenticating documents for proceedings. Sometimes statutes require notary authenticating for certain claims, but authenticating is general if somebody has an application for a job or even a tender, and he has to attach copies of certain documents like diplomas, language certifications. Keeping records and authenticated documents is in close connection with the general right of authenticating. One of the classic records notaries keep is the chattel mortgage register. Finally, some member states of the EU give exclusive right to special proceedings, such as probate actions or destroying securities. As you can see, notaries are a lot different than advocates. Their primary duty is not to represent a client, but to provide authentic services for the public. That is why that being a notary is not as risky as being an advocate. Notaries do not have to hunt for clients, as clients need their services. As you could see, legal profession has a different perspective in Europe than in the United States. These differences are in close connection with the specialities of the civil law legal systems, the supremacy and due process of law doctrines. The unique conception of a legal procedure had a major impact on legal profession. The mobility rules of the European Union try to expand this originally national world of the legal profession. Although differences in the legal regime of the member states are still significant, but the common EU law and the common market started to override the old situation when lawyers had to stick only to their national law in their home country. Thank you very much for your attention.